Hello and welcome to this Field Seymour Parts webinar. My name's Ian McRae and I head up the employment law team here, and I'm going to be taking you through some of the key employment law developments from last year which you need to be aware of when dealing with your employees in 2020. So I'm going to start off by talking about whistleblowing and whistleblowing legislation. So for those of you who aren't that familiar with this is the idea that employees can get added protections if they make a disclosure that is in the public interest and shows or tends to show that there's been a particular type of wrongdoing. So normally it's a disclosure about a breach of a legal obligation, a criminal offence, health and safety breaches, environmental concerns, or indeed concerns that wrongdoing about any of those things is being covered up. Now, if they make one of those protected disclosures, they get protection from being dismissed as a result or suffering a detriment. And what we've seen is a vast increase in the number of these claims over the past year. That's also borne out by the statistics from the Tribunal Service, which shows a nearly 20% year-on-year increase. And the reason these claims are becoming more commonplace is, firstly, employees don't need any length of service to bring a claim, so they can bring it on day one. And indeed, some of the cases I'm going to go on to talk about are about employees who brought claims during their probationary period. There's also, it's an uncapped liability. So for a normal unfair dismissal claim, there's a statutory cap on the value of that claim. But with a whistleblowing claim, in theory, the sky is the limit. There's no statutory cap on it, so there's no cap on loss of earnings. And indeed, they can claim injury to feelings in a detriment claim as well. The other thing that often gets employers worried about these claims, and means that they're a good tactical tool for employees, is that they can bring claims not only against the company, against the employer, but also against key individuals who work for them. So if there's a particular HR manager who's been bullying or harassing someone because a protected disclosure has been made, or maybe there's a particularly blameworthy director, they can actually face individual personal liability for their actions. And that does tend to focus your mind slightly. So as I say, we're seeing a lot of these claims, and there's a lot of developments in this area towards the end of last year. So I'm going to take you through 4 cases. First one is a case concerning Royal Mail. And in simple terms, in this case, an employee made a protected disclosure. So they made this disclosure of information in the public interest. And they were subjected to harassment and bullying and intimidation. Ultimately, though, they were dismissed on performance grounds. And the manager who made the decision to dismiss had no awareness that the employee had made these previous protected disclosures, these complaints about a breach of a legal obligation. And what happened in the initial decision on this case is that the employee lost. And they lost on the basis that if the manager had no awareness of the protected disclosure, how could the dismissal be by reason of it? However, the case goes all the way up to the Supreme Court, and there they disagree, and they reach a determination that actually this wasn't automatically unfair dismissal. This employee had been dismissed by reason of the disclosures that had been made. And the reason and the basis for this decision was that they said there had been manipulation by a person in the hierarchy of responsibility above the employee. So in simple terms, up the management chain, there had been a manipulation of the situation. So the manager who ultimately made the decision to dismiss, whilst thinking they were doing so legitimately on performance grounds, had actually been manipulated by others, and the dismissal was in fact by reason of the disclosures the employee had made. Now, the importance of this case is that this case is not only going to influence whistleblowing cases in future, but actually any sort of unfair dismissal case. And it's going to leave it open for claimants to argue, for employees to argue, that whilst the person who's made the decision to dismiss them has done so on purportedly or on the face of it legitimate grounds, in reality, behind the scenes, there is this conspiracy, there is this plan to oust them from the business on grounds that are not legitimate. And so what we expect to see is a lot more employees arguing cases where even on the face of it, it looks like the dismissal is legitimate for example on performance grounds like here, and saying that actually the reality of it is there's been manipulation by this hierarchy of management above them. So moving on to second case I want to talk about, case of Ibrahim. And as some of you may recall, back in 2013, the whistleblowing legislation was changed. And it was changed to make sure that employees only got their protected status if they made disclosures in the public interest. And the reason that change was made is a lot of employees were making complaints about breach of their own employment contract and saying, I am concerned there's been a breach of a legal obligation because you're not complying with my contract of employment. So no wider public interest requirement. So the law changed in 2013 to actually include there to be a public interest element of the disclosure as a requirement. Now the questions has raised since that point in terms of, well, how far does that go? And in this case, Mr. Ibrahim, who was an interpreter, I believe, at a number of private hospitals, rumours started to spread that he was responsible for breach of patient confidentiality. Now, he was concerned about that, principally, I think, because he felt there was some sort of defamation on his character, and he asked for an investigation into the matter because he wants to clear his name. Now, he's subsequently dismissed as a result. Now, he lost at the Employment Tribunal and indeed at the Employment Appeal Tribunal, and the case proceeds up the court through to the Court of Appeal. Now, what the Court of Appeal said is that even in cases such as this, where it appears that the disclosure has been made purely in an individual's self-interest, so for example here on the face of it, it appeared quite clear that Mr. Ibrahim was making this disclosure because he was concerned about himself, about defamation of his own character, rather than there being a wider public interest. But the Court of Appeal said that even in cases such as this, the employee must be given the right to explain and give evidence as to why it is in the wider public interest. And so they sent the case back down to the Employment Tribunal to say, you must hear evidence from Mr. Ibrahim on that matter. Now, the reason this is important is it demonstrates that even in cases where, as an employer, you may be facing a disclosure from an employee that appears solely about themselves, it is still open for them to argue that there is some wider public interest. And public interest for these purposes means not necessarily the full 60 million or however million people are in the UK now, but it can just be a relatively small group. So if Mr. Ibrahim was, for example, concerned about a group of employees or was concerned about a group of patients, that would be sufficient to tick the public interest box. So just a word to be of caution in relying too heavily on that public interest requirement. So moving on to the third case of Elysium Healthcare. And this concerns whether or not an employee, when they make their disclosure, do they have to specifically state that there's been a breach of a legal obligation or there's criminal wrongdoing or whatever the malpractice is? Do they have to state or make it clear that it is a breach of that nature? Now, in this case, the employee complained that a supervisor was acting contrary to rules set out in a staff handbook. And from recollection, the employee worked in an institution dealing with people detained under the Mental Health Act, so seriously unwell people, and he was concerned or was complaining that his supervisor was eating the patient's food and that this was in breach of the staff handbook. Now, he didn't make any specific allegation that this was a legal breach, but the evidence in the case suggested that he viewed the handbook as more than guidance, and this was more than just a mere sort of moral matter. And in this case, it was actually made out that this complaint about his supervisor eating the patient's food was sufficient to qualify as a protected disclosure. And that was despite the fact that the employee did not believe the handbook to be contractual, and had not pointed out, a particular act or a particular clause or a particular legal obligation that was being breached. The mere fact that he believed the handbook to have status and to be more than mere guidance was enough to tick his belief that he believed there was a breach of a legal obligation. So again, a word of caution, as and when you get complaints in or disclosures in from employees, even if they're not saying you're in breach of section X of a particular act or pointing to a clause in a particular contract, you still need to be careful because they can still qualify as protected disclosures. Now, the final case I'm going to talk about on whistleblowing before we move on to something different is actually an employment tribunal decision. So I don't normally talk about these in our webinars because they're not binding. They're not binding on other courts or tribunals. However, this case concerning berry marketing actually gives an indication of a potential angle for employees to pursue in future. And the case here concerned an employee who was concerned about a data breach, and he was researching and looking into how he could make a protected disclosure about this breach of data protection law. So he was researching how to make a complaint to the Information Commissioner. He hadn't actually made a disclosure to his employer about his concerns, but the employer was aware that he was researching and planning to make this disclosure. I think he said words to his employer along the lines of, "I'm going to bring this company down." Now, he was subjected to a detriment on the findings of this case because the employer was aware he was planning to make a protected disclosure. And the employment tribunal in this case concluded that the mere fact that he was planning and researching how to make a disclosure was enough to give him protection under the law. So he hadn't actually made a disclosure, but the fact he was planning and researching was enough to give him that protection. And they basically interpreted the legislation to give effect to the European Convention of Human Rights, in particular about freedom of expression. And the employee in this case was successful with their claim. Now, as I say, this is an employment tribunal decision, so not binding on other tribunals or courts, but I think you can anticipate that employees, particularly where they haven't actually made a disclosure, will be relying upon this and running this argument more and more in cases. This case, I don't believe, is going to be subject to an appeal, so I think the financial value of it was only around £2,500, so probably not enough there to fight it up to the Employment Appeal Tribunal. So we have to await further guidance from the higher courts, but something just to be aware of as employers. So let's move on to something completely different. And I want to talk about restrictive covenants. So these are the post-termination restrictions that you commonly get in employment contracts. So that say, for example, once your employment terminates, you shall not work for a competitor for 3 months. You shall not steal our clients. You shall not solicit our employees. And we had a Supreme Court decision on this in 2019. And the reason that's noteworthy is I think it's the first Supreme Court decision in this area for over 100 years. And it actually has some bearing in terms of the enforceability of these restrictions moving forward. Now, this case concerned a non-compete provision in an employment contract that ultimately hadn't been particularly well drafted. It included a provision in it that it prevented the employee being interested in a competitor after termination. And the employee argued, well, this is far too broad, this is unfair, it's an unreasonable restraint of trade, because it is preventing me from even having, a tiny minority shareholding in a competitor, and therefore there's no legitimate basis for this restriction, and I shouldn't be bound by it. So this case proceeds through the courts, ends up at the Supreme Court, and there's two key elements to their decision. The first one is they do say that it can be appropriate to restrict shareholdings in a competitor. Although they do make it clear that minority or very small shareholdings, there would be no legal basis normally for restricting those. So there has to be some restriction on those smaller elements. They need to be carved out of scope. But the key bit of the decision is that there has always been a principle in English law when looking at these post-termination restrictions, that if the clause is too broad or too wide, then the court could apply what's called the blue pencil test. And in very simple terms, that basically meant that if a clause or subclause of a contract was too broad, that could be struck out and the remainder of the restrictions could still stand. And that's why you often see in the drafting of these contracts, these restrictions, everything is broken down into very small subclauses. But what they did in this case is actually they said that that blue pencil test could be used to delete the word interested from the middle of that clause, and therefore that would render the clause enforceable. In short, they're saying it is easier and it is possible to make sort of deletions from clauses to make these clauses enforceable. So what's the implications of this? Well, as an employer, there's probably two ways you end up facing post-termination restrictions. The first one is obviously you've got an incoming employee, you look at their contract, there's some restrictions in there. The impact of this case is that even if those restrictions look poorly drafted or too broad, you still need to be careful because with the application of this new wider blue pencil test, there's an increased chance that the ex-employer could successfully enforce them. So just caution there. If the other side of it, of course, is when you have an employee who leaves you and you want to enforce post-termination restrictions against them. What we would still say is don't rely upon the blue pencil test. Get your clauses drafted properly in the first instance. There's two key reasons for that. One is you might not need to litigate them at all. You might not even need to trouble the court. If you've got a well-drafted clause, you may be able to get the employee to comply with that without incurring considerable costs in terms of having to litigate the matter. Secondly, there was a hint in this case that if you are only able to successfully enforce your restrictions with help from the court, i.e. them deleting parts of your clause to make it enforceable, there was a suggestion that even though that you may have won, you may not recover your legal costs because ultimately you've had to rely upon the court to do your work for you. And if that's the case, legal costs in these proceedings can be considerable, and that could really sort of tarnish any victory you've got in terms of enforcing the clause. So, moving on to an entirely different area about employee suspension. So this case concerns an employee who was a teacher and they were facing allegations that they had used inappropriate force against, I think, 2 or 3 children. They were suspended from work as a result, and the teacher, the employee, resigned and claimed that the suspension was in breach of contract. Now, the key part of this decision is that they found that suspension in this case, maybe somewhat unsurprisingly, was an appropriate thing to do. There was obviously a risk to the children, and indeed a very serious allegation. But what they also made clear in this case is that suspension will not always be appropriate, and it can sometimes be a breach of contract. So a few points to think about as and when you're facing potentially having to suspend an employee, which will normally be in disciplinary circumstances. So firstly, check if you've got an express right in your employment contract. Hopefully you do, and that will make your life easier. If you don't, you might want to get your template reviewed to make sure it's there in future. If you don't have an express right, you need to consider whether you've got an implied right. So are the circumstances such that it is so obvious that you would need to suspend an employee in those circumstances? You then need to have a reasonable and proper cause for the suspension. So examples of those might be that there is a risk that the employee might interfere with your disciplinary investigation. That can be a fair ground for suspension. Or it might be because you're concerned that it might happen again, or that simply the matter is so serious you can't keep them in your business whilst you investigate it. You should, however, always consider alternative options. So, for example, you might want to consider whether the employee should work from home, or whether you can change their roles and duties, or in some way restrict their activities. so that those concerns you've got, whether it's their ability to interfere with an investigation or it's the possibility they might do something again, is there an alternative way of ensuring that won't happen without the suspension? If you are going to suspend, you need to keep it as short as possible, so you need to crack on with your investigation and your disciplinary process, and you need to keep it regularly under review, and ideally to document that as well, to show that you've actually considered whether it is still appropriate. And you can have circumstances where something starts off as looks like gross misconduct and you suspend the employee, but during the course of the investigation you realise it's not as serious as you thought. In those circumstances, you need to get the employee back into work as quickly as possible, even if there's still a disciplinary hearing to follow. And also always consider your external communications. You need to be trying to ensure that your employee is not penalised as a result of their suspension. So that's a summary of some of the key developments from 2019. Obviously, we don't have time to go through all of them. It all comes with the normal caveat. This is obviously only a very brief introductory summary. You should always take legal advice on your own circumstances. If you are interested in staying up to date with employment law, please do check out the seminars, podcasts, email updates and pocket guides we offer. You can find them all on our website. And equally, please do get in touch if you have any suggestions for any further webinars.